Great. I don't know, for some reason, Kelly, I'm not able to hear you, but I will get started. Other trust structures and issues, and some of this, again, will be a little bit of recap from some of the other items we discussed earlier in some of our topics. You already know about me. So I will head in to the material. Minor's trust. So oftentimes there's a gift or transfer that would essentially be able to be given to a minor underage beneficiaries. So ultimately, at the end of the day, we don't want to, we can give a gift outright, obviously, to an individual, but a minor doesn't have capacity. So at the end of the day, we wanted to make sure that we're gifting in a trust for a minor. And those are typically, depending on whether you want to ensure that the asset is outside of a taxable estate, an irrevocable trust with a adult beneficiary. And the distribution provisions can be like anything else, where they're essentially being able to distribute assets for the minor beneficiary for things like health, education, maintenance, and support. And so that type of trust is really, I mean, I don't really call them minor trusts, I guess, in practice. They're essentially gifting trusts where the beneficiary happens to be a minor. And then we're incorporating provisions to see at what point, what age we would be transitioning the control. Sometimes it's an ongoing trust for their lifetime because we want a dynasty type provision. So the transfer of control occurs in the form of them taking over as trustee of the trust, versus distributions over time based on age. Like at 30, you get 1/3, 35, you get 2/3, and 40, you would get the remainder. So again, depending on the goals and objectives and the complexity of the estate, it ultimately depends on the grantor's intent. Minor's trust could also refer to things that would happen via testamentary, a will through a probate process, where again, a beneficiary might be a minor as well too. We also talked a little bit about IRAs and the Secure Act and the change to the law. I mean, IRA trusts after the Secure Act are a little bit different. For many years, a common strategy in the transfer of wealth was, the IRAs and the 401ks, just, the owner would take the required minimum distributions, leave the balance to that designated beneficiary, which we defined earlier today. And the funds within that trust or to that beneficiary would grow tax deferred, and they had their lifetime to pull the money out. And that designation through beneficiary could be outright right to an individual, or as we mentioned earlier, it could be through a see-through or look-through trust. And that trust had to contain provisions directed where the trust assets would go, could provide sponsor provisions. It might be because the minor is a beneficiary, and then asset protection from creditors. And so using this strategy, the tax deferred retirement account had the potential to become basically like a dynasty trust. The beneficiary could stretch that RMD over their life expectancy. And we talked about how that beneficiary of a qualified retirement account must be a natural person to be considered that designated beneficiary. Now, the requirements specifically of a look-through or see-through trust, it must be valid under state law. We talked about that earlier. It must be irrevocable or become irrevocable on the death of the owner. The beneficiaries must be clearly identifiable within the trust. And then the copy of the trust needs to be provided to the plan administrator no later than October 1st following the year of the owner's death. And oftentimes the custodian of the IRA will want like a letter from myself certifying that this is a look-through or see-through trust. They're not going to do the analysis on their own. They would want to rely on my declaration or my confirming that. And it could be in the form of two types of distributions. One is purely just a conduit, and all the income and principal of that passing through that look-through or see-through IRA trust are immediately distributed out to the beneficiary. Now, they can't take the corpus, but those RMDs are just set to push out. And I would say in general, this is probably the most common of the look-through and see-through trusts that I would draft, versus an accumulation trust where those distributes, they accumulate, the RMDs distribute distributions accumulate for future, and the trustee has full discretion on whether to push those funds out, essentially. And again, that helps a lot with asset protection. Well, the Secure Act became in effect on January 1st, 2020, and it really changed the whole rules around the qualified retirement accounts. And there's been a Secure Act 2.0 recently that increased the age of RMDs. We're going to head up to 72, now 73. And that's when you need to start pulling out those required minimum distribution each year. But for the most part, what it meant for a lot of beneficiaries is they would have, as I mentioned earlier, that 10-year to withdraw the funds from the retirement account. And there is an exception to the rule, as I mentioned, those eligible designated beneficiaries, those EDBs, which would be the spouse, a disabled beneficiary, someone who's chronically ill, or who's no more than 10 years younger than the original account owner. But really, these IRA trusts fit well for, despite the Secure Act, when we're looking at creditor protection, someone who might just blow through this money very quickly. And again, prior to the Secure Act, you could still withdraw that over the lifetime. And now the conduit trusts really only are available, those protections during that 10-year period until the beneficiary is an eligible designated beneficiary. And if there are multiple beneficiaries, you do need to be careful because all the beneficiaries must be those eligible designated beneficiaries. Otherwise, those stretch out provisions are automatically eliminated and all the funds must be distributed in the 10-year under the 10-year rule. If you think of that IRA trust and you have the surviving spouse as the only named beneficiary, then the distributions could be very easily stretched out over the survivor spouse lifetimes, with the RMDs beginning at the later of the year after the owner's death, or when that owner would have been 72 or in the future 73. So now after the surviving spouse's death, the next level of beneficiaries are going to be subject to the 10-year rule. So that's going to be inevitable at some point. So I suppose I think it would be preferential to create separate shares within that IRA trust so that the 10-year rule will be separately applied when each child, if they're minors, attain that age of majority. I don't typically use the IRA trust in a surviving spouse scenario. It gets a little bit complicated, but it definitely is something that's been considered for cases where we have a blended family situation. We're worried about, huge amount of assets. Sometimes the retirement funds are really the largest part of the situation of that, a state as a whole, and they want to be clear that you can't just change the distribution provisions of this trust. It's going to follow along through what the terms of the trust say. So it might be helpful, but it does certainly complicate the administration more than just a simple spousal rollover that the spouse would do if they were the direct beneficiary. Now, accumulation trust is going to provide discretion, the trustee with the discretion to decide whether to pay out or retain or accumulate the distribution from that inherited retirement account. And that provides that asset protection and from outside creditors and spendthrift beneficiary. Now, again, under the Secure Act, the total distribution of the account still must be completed within that 10 years. And then you kind of look at the downsides of that accumulation trust, because it would trigger increased tax liability if the distributions are retained, because, as I mentioned earlier, the trusts are taxed at that sort of compressed tax bracket, and they're subject to the top, income tax rate once they have annual income over, I want to say $14,000, $14,450, I believe. So really, an individual would need closer to over $500,000 of annual income to, I think as a married couple, about $600 to really reach that max. So those are already in the highest tax bracket. It doesn't matter, but the accumulation trust works against those distributions being taxed at a lower rate. So again, it really kind of the driving force had to be an incredible, an intense desire to have that asset protection component. So I think given the Secure Act and the Secure Act 2.0, it's really worthwhile to consider tax planning and looking at Roth IRAs and backdoor Roth conversions. Different, topic, different session, but it's certainly something that I think is important to look at with your clients and their CPAs. Pet trusts are fun. I have some unique pet trusts that I've actually not only drafted, but I've administered. And for, some of my clients, this is their the furry family, and this is their children. And the hardest one was the African parrot or parakeet, where they live, likely going to outlive my clients. They're about lifespan of 80 years or so. And so we had to kind of figure out how to have this ongoing trust that would benefit it. And, they really love the pets more than they love their people. And we have all heard that famous case where the cat, I think it was the iconic fashion designer, and the cat had its own, modeling contract. But I believe the designer left her about $1.5 million when he passed away in 2019. And so it was kind of an interesting thing. Or the $12 million pet trust for Leona Helmsley. Anyway, I think there's a Netflix show about the German Shepherd that inherited it. But anyway, helping the pet client plan for surviving pets is really important. And then you have sometimes pets that have special needs. And I don't think it's fair or realistic to assume the family members were going to assume that responsibility. So anyway, pet trusts would definitely be part of your initial intake and questionnaire. And in the 90s, there was a law, the Uniform Probate Code, to basically essentially validate a trust that was designated for domestic pet and animal and offspring. So all 50 states have adopted a pet trust statute. In California, we have a probate code section that sets out certain requirements that can serve as a guide to drafting a pet trust, but really it should include the types of pets involved, the specific service, purpose behind it, the standard of care. I had one where, the dog needed to be, certain providers, certain caregivers, certain veterinarians, certain water and food and diet. But there are some common problems when you look at, just poor drafting, enforceability issues, the rule against perpetuities. So I think they should, when you're drafting a pet trust, I think you should be specific, and ensure that there's the ability to enforce the trust. Like, consider a pet advisor in addition to the trustee that kind of oversees, or trust protector or trust advisor, because there can be kind of an easier abuse of that authority without that pet obviously being able to enforce their rights, essentially. So, and then you kind of have to think about I've had cases where we're worried too much about the issue of the surviving pet, but I suppose the trust could go on for that pet's issue, and ultimately would want to maybe plan for that. Pet trust could be testamentary trust, it could be standalone trust, included in the revocable living trust. You want to look at, again, the key role players, trustees, caregivers, a care panel, how to identify the pet. And then oftentimes the charities are the remainder beneficiaries of whatever's left. And, it's wonderful how to have the charitable component, but they then do have a right to an accounting and information related to that trust. So you just want to be aware of that as well, too, especially if you or someone or you're representing is serving as trustee of that pet trust. So I think I mentioned a while back that I don't, full disclosure, do Medicaid or Medi-Cal planning, but I do know enough to be dangerous. And I do have colleagues in my office who specialize in elder law, and it changed, again, as I mentioned, pretty dramatically in this last year, because as of 2024, Medi-Cal is not a needs-based, it's not asset-based, right? It's based on income. But there were Medicaid qualifying income-only trusts where the corpus would be removed from something that would be countable against the person for purposes of qualifying. And so I think it's important to remember that that's still valid and, going to be important in a lot of other states. And, take a look at that. But a Miller Trust essentially allows that Medicaid applicant to directly deposit a portion of all of their income to the trust. And it won't also be counted towards the income limit, which is relevant in California. And then the recipient will be able to qualify or maintain qualification for long-term care Medicaid benefits. And, a couple of things to be aware of on this type of trust. It can only be established by either the Medicaid applicant / recipient or their guardian. And the trustee really does need to be, and cannot be the applicant or the recipient. The trustee must be someone other than, typically the family member who is providing coordinated care often is the trustee. And yes, I am filling in for another speaker. So if you look at the materials, the PowerPoint is not matching the order of the materials, but it's all in there. So, we're doing our best, but you'll see that each of these topics corresponds to an item in that section or a number in the section. It's just the slides appears to be out of order with the numbering in the section, okay? All right. Other kind of conditions that the Miller Trust needs to be compliant with or keep in mind, it must be irrevocable. Income must be deposited in the month it's received. It cannot contain other resources than monthly income. It, again, as I mentioned, needs to have a third-party trustee. Upon the death of the recipients, the state must be the primary beneficiary of the remaining funds. So it's essentially, has payback provisions, as I mentioned, like a first-party special needs trust. And so California doesn't allow this, and again, it's not really a thing here, so I apologize for my limit of knowledge related to it. But what I've found in California that's been a really useful tool and cuts down on the costs, and I used to work for a large corporate trustee that would administer it as a pooled trust, and it allows, has a master trust document, so an individual can join this pooled trust with a third-party trustee administering it. The fees are going to be lower. They don't need an attorney to draft the trust. And then typically the pooled trust is designated as the shelter for any surplus income to then cover any basic benefits of the person with the disability or the special needs. And it allows that person to be able to spend down or kind of shelter that excess income and still qualify for the needs-based benefits. Asset protection trust. So we talked a lot about how oftentimes the benefit, someone would want to set up a trust and the benefit of that irrevocable trust, whether it's sheltering it from estate taxes, but also, has a desired effect of protecting the assets from creditor claims, divorce, bankruptcy, things like that. I think it's important to also note that a asset protection trust, self-settled asset protection trust, is not allowed in California. So at the end of the day, you're looking at jurisdictions like Nevada and Delaware and Alaska that allow self-settled trusts, something you're setting up where you want to be the beneficiary of. But the asset protection trust that I come across most oftentimes really can be used synonymously with a dynasty trust, which has the additional effect of not only removing the assets from taxable estate, but having that ongoing trust protect from assets. So if you're in California, you can co-counsel with, let's say, local counsel in Nevada. One of the most well-known persons who really touts Nevada as the best jurisdiction for a self-settled domestic asset protection trust would be Steve Oceans. His website has a great kind of information around, the different jurisdictions and comparing which ones, and then some of these jurisdictions have abolished the rule against perpetuity. So it's really just a great, a great place to start. We've also talked about, and I think this is covered in a couple of places, irrevocable life insurance trusts. So at the end of the day, the irrevocable life insurance trust has the purpose of sheltering the death benefit from estate taxes. So if I have a $10 million estate, the exemption is 13, and I add a $10 million life insurance policy into the trust, then into my estate, then essentially, without putting it in a life insurance trust, I'm going to have an issue with the death benefit being subject to taxes if I'm, not married. So at the end of the day, we look at an irrevocable life insurance trust to have someone else be the trustee to hold ownership of that life insurance policy. And then essentially that life insurance policy would pay out to, the death benefit would pay out to that trust and be outside of the taxable estate. And, you can kind of play with how you want to set these up, because sometimes, typically the life insurance trust is a grantor trust, but it can be a non-grantor trust. But if it's a grantor trust, maybe you want to, incorporate life insurance trust provisions within the intentionally defective grantor trust and create a dual purpose for both of those, other assets that you can gift into that trust. And one of the best ways to kind of make it, an IDGIT with life insurance provisions to allow the trustee to own and purchase and pay for, that is you get the benefit of being able to say, okay, well, let me put just this chunk of, change, or this income producing asset into this irrevocable trust that holds a life insurance. And basically at the end of the day, you get to use the income produced from that asset just to pay the premium. So you don't have to worry about the crummy powers and the annual gift exclusion or ongoing gift returns. So that's a really great way or mechanism. Incomplete non-grantor trust, I don't tend to really use these or see them in a lot of practice. Probably the best example of the case in which I used a Nevada-based incomplete non-grantor trust was in the purpose of a NING or a DING, a Nevada incomplete non-grantor trust, or a DING, which is a Delaware-based non-grantor trust. They are typically irrevocable, but they allowed, when they were still allowed in California before Governor Newsom passed a law where it really doesn't, the strategy doesn't work, I was able to set up a Nevada-based trust that essentially my client gifted or transferred over their part of their business into that trust. So when they sold it, because the trust was based out of Nevada, they were able to avoid paying California income tax. And that was a great strategy because it saved them a lot of income tax on the sale of a very, very large business interest. They needed a third party trustee based out of Nevada. They needed an adverse party or non-adverse party to approve the distributions out of that. So it was complicated from an administrative standpoint, but they really loved not paying that income tax on the sale of a very large asset. Again, the strategy doesn't work in California anymore, and we knew it was a matter of time. Something sounds really too good for it to, oftentimes it is. So we kind of knew at some point the FTB would be looking at these and scrutinizing them a lot more. And probably as part of this transfer, the biggest expense was having a tax opinion written to see if this would actually work or pass muster in an audit, which we felt it would at the time under the prior law. And again, not so much anymore. So we're kind of looking at unwinding that trust at this point. Also in California, we don't, or at least I don't have, in LA, a lot of gun trusts, but they have, they do serve a purpose, and you might come across it, and you might be in a state where it is important to take a look at the gun trusts. And if you're a Wealth Council member, which is kind of a helpful way to start getting forms and drafting, they do have a great section on this and do have a gun trust. But any firearm transfer in an estate, a simple revolver, a pistol, a rifle, it can present problems for the personal representative. I mean, it's risky. You know, an old family friend distributes, you know, his white rifle to a beneficiary, but the trustee doesn't understand that that beneficiary is now subject to a restraining order, and they violated that. The trustee could be liable. So I think it's you know, how do we best mitigate that risk? And I think the protective language included in the instructions should verify that the beneficiary is, you know, a lawful recipient of that, and, you know, maybe consider the use of a gun trust. And I think the advantages of a gun trust, just in short, is, you know, over individually, you know, owning the Title II firearms is multiple trustees can possess the firearms in the trust. The family members with access to the firearms, you know, could be actually have constructive possession of the firearms, or appointing these persons as trustee protects them against that prosecution. If a trustee passes away, the trust continues to exist and has a successor trustee. I guess there is a avoidance of transfer tax. So, you know, and there's, again, specific requirements that's in the materials. You can kind of read through it. The trust must prohibit the possession of firearm of anyone other than the trustees of the trust. It has to restrict prohibited persons as defined in that Firearm Act from possessing the firearms in the trust, has to provide for automatic removal of any trustee who becomes a permitted person. There's a whole host of the things the trust is going to ensure that it's compliant with. So anyway, like I said, hopefully if that's something that you think is important, you would read up on it. I do have one question I think I want to try and answer before we flip back over to the next speaker. Is the case where my client transferred the sale of the portion of the California-based business. The clients did not have residency in Nevada. That was the whole point. So they needed a third-party trustee that the trust would be administered out of. So we used a trust company based out of Nevada, a trust distributed provider. None of the fiduciary persons in that trust besides the beneficiary had connections to California. And then once the business was sold and they had liquidity, they cannot turn around and go buy, you know, a house in California or real estate in California. They really do need to cut off those ties. But again, those incomplete, the ings and the nings really don't work here much anymore. So anyway, I'm going to wrap up right on time, and it looks like Kelly's audio is not working, so I think it's going to transition to Ali next, and then back to me.